Yeah,
Cool.
thanks.
Yeah, you bet. Well, so we'll go ahead and jump into contract unless anybody have questions before we get started, whether it's contract, buy and sell, anything else. Nothing. Okay. We will pick it up where we left off. Unfortunately, I don't know where that is. Does anyone know where we left off last week? Roughly? I know we talked about ILC, or we talked about OEC, the owner's extended coverage, which has to do with the title commitment. And I know we talked about new ILC and survey a little bit in relation to the fact that many agents, when they're writing the offer, they'll put this only if required by title company piece right here, which is completely the wrong section to address, title company related stuff. The title company would typically only require an ILC if you're asking for owner's extended coverage. And even then, it's not on all properties. If the property is in, a typical residential detached neighborhood that's been surveyed and everything else, in most cases, title doesn't require an ILC to provide this owner's extended coverage anyway. And so if you were wanting to add some provision to the contract that was saying, hey, we want the seller to pay for an ILC if it's required by title, you could either come over here and check this other box, right, and say, seller's not only going to be required to purchase owner's extended coverage, but if title requires an ILC in order to provide owner's extended coverage, seller would also be obligated to, pay for that as well. You could certainly check the other box and put that here, or you can go down into additional provisions and you can put it there. But what Section 9 is asking is, regardless of what title may or may not require, does the buyer want to have an ILC done? Do they want to have a survey done? Do they want to have a contingency done? Even if title says, no, we're not going to require it. Okay. And if title requires it because of the owner's extended coverage piece, then the buyer is not, stuck as far as being able to get out of the contract or not being able to get out of the contract due to something that turns up in that ILC or in that survey. Certainly, if there's something that's disclosed on there, it would affect the title commitment itself. And if there's something, if you guys remember, there's a little bit of a hidden deadline in here in Section 8. And basically what it says is that if there's something that changes the title commitment that, adds some kind of requirement or changes one of the exceptions or something like that, then the buyer would have the right to terminate based on their review of that anyway within 10 days. Okay. So Section 9 is not the proper section to address if required by the title company. You either put that up in Section 8, put it down in additional provisions referring back to Section 8. But Section 9 is just, does the buyer want that contingency for an ILC or some other form of survey? If the buyer does, then you could certainly check one of the boxes, right? Whatever the buyer is asking for. If it's an ILC, great, check this box. There's various other forms of surveys, but probably typically the most common one you would deal with other than an ILC is going to be something called an improvement survey plat. And an improvement survey plat is just, it's a survey that shows, here's the lot lines, here's where the improvements are located. There's a home here, a detached garage here, there's a shed here, right? Here's any easements on the property and whatever else. So it's called an improvement survey plat. And, in many cases, if your client, like I had a client who wanted to build a 900 square foot detached garage in his backyard. And so if he was going to do that, he was going to have to get an improvement survey plat and provide that to the city. So that's going to be a little bit more accurate, a little bit more precise than that improvement location certificate. Okay.
Yeah, see,
So,
my buyers,
yep.
my buyers had to get a new survey done because they needed an elevation cert because it was in a flood zone.
Yep.
Could have said, nope, we don't need it, but their lender requested it. So they had to get it done.
Yep. So, and that's a good point. And that being said, so if it's a lender requirement, right, then we're not really, again, it's not in regards to this section, but certainly those are things that a lender may require. But if it's tied to the loan, then it's going to be in section 5, right,
Yep.
which is talks about all the
Conditions.
financing conditions and that type of stuff. So buyer would still have a right to terminate if either they couldn't get the elevation cert, or if it was, not suitable to them, not suitable to the lender, right, then they would have the right to terminate under section 5. So yeah, there's certainly other forms of surveys as well, but those are the ones you're going to come across the most. And it is possible to ask for the seller to pay for it. Now, maybe not in this market, right? Buyers bending over backwards just to get an offer accepted. So if the buyer wants one, then probably the buyer is going to not only order it, but the buyer is also going to pay for it, right? So again, you don't need to come in here and, let's say you had checked the box. Doesn't really matter. Even if you check the buyer box, you don't have to put in here only if required by the title company or whatever else, because there's this language in 9.2 anyway. But A, this isn't the correct section to address this, but B, even if it was, right, you don't need to put that language, because what it says down here is that buyer may select a new ILC or a new survey different than initially specified if there's no additional cost to the seller or change to the new ILC or survey objection deadline. And buyer sole subjective discretion could also waive the new ILC or survey if it was done prior to seller incurring the cost for paying for it, right? So buyer, just because they check these boxes doesn't mean that they have to do them. They could certainly check the boxes and then say, no, I don't want to pay for one. I've decided against doing it, whatever. That's okay. They don't have to do it. Okay. But if you have a seller and a buyer's agent writes an offer, and this comes across and it has a new ILC or new survey improvement survey plat or whatever, and it says the seller is going to order and or the seller is going to pay, right? And forget about any verbiage here. You got to be a little bit careful, because effectively you're obligating the seller to pay for that item, even if it's not required by the title company. Now, if they wrote only if required by title company in this section, which many agents do because they just don't understand that concept, right, then you might have a way to wiggle out of it, even though it was the improper place to address it in the first place, right? You may have a way to wiggle out of paying for it. But if they don't have this verbiage in here and they've checked the boxes that say seller, and let's just say they check the ILC box, it doesn't matter whether title is requiring it or not. They're asking the seller to pay for it, even if title says, no, we don't need it. Okay. So be careful when you're working with the seller, to check these boxes, right? Check the verbiage. It really shouldn't be here, but you're probably going to come across that anyway. Okay.
So Jesse,
yeah.
So Jesse, just so I can get this clarified. So
yep.
Jerry mentioned that she had to do it. Her lender required it because of a flood. So if it came back that it was in a flood zone and the lender says, well, we're not going to give you the loan, then you can use 5 to get out of that contract, correct?
Yeah. And you could also make an argument, depending on, when your dates and deadlines are structured, you could also make an argument with regards to your insurance.
Okay.
What the deadline means, right, for property insurance is not that the buyer can't get insurance. It's that the insurance is not acceptable to the buyer in the buyer's sole subjective discretion. And so they may be able to get insurance instead of, $1,400 per year. It's going to cost them $2,600 per year. And they go, whoa, hold on. I didn't sign up for flood insurance, right? I don't have the ability to do it, or I don't want to pay that much. So you may have an argument under your property insurance termination deadline as well. But if it's a lender requirement and the lender disapproves of it, then yeah, you could certainly use your loan termination. What you can't do is you can't try to terminate. Well, you could try to terminate after your deadline. The other broker's probably going to be smart enough to tell you like, no, you have no right to terminate. Right. But what you can't do is you can't use a contingency here for something other than what it is intended to be used for, right? So probably the biggest thing that you're going to come across, right, is buyers are like, hey, yeah, we just did our inspection, and the inspection's fine. You know, we would otherwise be okay with it, but there's this other house that just popped up down the street that's a little bit bigger, a little bit nicer, and it's actually a little bit less expensive. It suits our needs better. It has a bigger yard. Like, we would really like to go pursue that. So let's try to use our inspection objection and you know, or our inspection termination deadline and just terminate under inspection so that we can go pursue this other property, right? Well, that's not what your inspection objection or termination are for. Now, in the real world, does that happen? Yeah. And do people get caught? Yeah, they do. Do they get caught all the time? Not necessarily. Okay. But just know, if that's what your client is doing, then their earnest money is at risk, right? And so the conversation should be, well, hey, if it's really so that we can go pursue this other property, then let's just turn over the earnest money to the sellers, and then we'll go pursue this other property. Is it worth it for you to do that, or is it not? Because I can give you a dozen ways to get out of this contract that you have no right to actually terminate for, but that doesn't mean that the seller may not come back to you later, right? And try to sue you for breach of contract, bad faith, whatever else, right? And so at some point, you may still be on the hook for not only your earnest money, but also legal fees and court costs and all that other stuff if the seller finds out about your little scheme, okay? So be careful about doing that. You can't just, you know, I saw a post either yesterday or this morning on one of the national pages that was like, oh, well, you know, we still have our loan termination way out there. And so if this came up, we would just use that to terminate, right? And it's like, it had nothing to do with the loan. And so, you know, I think brokers have this misconception of like, I can use any contingency for anything. And it's like, well, then why not just have one deadline that's like your drop dead deadline to get out for any reason? Our contract isn't structured that way for a reason. Our contingencies are tied to specific objections that the buyer may have, right? And so you can't just use them for anything, okay?
No.
So section 9.1.3, what this says is that, you know, buyer, seller, the issuer of the title commitment, or in other words, the title company, right? And then whoever else that you write in here will receive a new ILC and new survey on or before the deadline. But what you don't need to write in here, you don't need to write, you know, yourself, you don't need to write the other agent, you don't need to write the lender, you don't need to really write anyone else, because what 9.1.4 says is that the new ILC or new survey has to be certified by the surveyor to all those who are to receive the new ILC or the new survey, which is defined here, right? Buyer, seller, title company, and then whoever else you list here. Well, in order to get these certifications by the surveyor, it costs extra money to do that, okay? And so, you know, if you're writing out here that, you know, 17 parties need to receive some kind of certification in regards to the ILC or the survey, you're just racking up the cost of doing that, okay? So you don't need to write the agents, you don't need to write the lender or anybody else, unless for some reason someone else has a vested interest in having an actual certified copy. You don't need a certified copy for most things, right? That you could just have a PDF copy and that's good enough, okay? Obviously, buyer, we already talked about this, they could select a new ILC or survey and they initially sought, as long as there's no extra cost to the seller, or they can choose to waive it if they would like to, okay? So they don't have to just because they check one of those boxes. 9.3 says buyer has the right to review and object to that ILC or the survey. And if it's not timely received by the buyer, unsatisfactory after the buyer does receive it, right, then buyer can do any one of these things. They can do a notice to terminate, right? If there's something on there that they don't like, they can terminate, or they can do an objection, right? And so they would do an objection, objecting to, you know, with a written description of whatever it was that was shown on there that wasn't satisfactory to them, that they want the seller to correct, okay? And if the buyer does object, then there needs to be a written resolution by that new ILC or new survey resolution deadline. Doesn't mean that the item has to be corrected by the deadline, but there has to be some form of written agreement as to what is going to happen by the deadline, or else your contract will terminate, just like most of our other contingencies in the contract, right? So make sure you don't go past that deadline. If the buyer does have an objection, obviously the buyer can choose to withdraw their objection, just like on the inspection, right? As long as that's done prior to that survey deadline, okay? So any questions on survey stuff? Okay. So section 10 is kind of a fun one. It's a long one. This has to do with disclosure, right? Adverse material facts, inspections, all that fun stuff. So what section 10.1 says is that by that seller's property disclosure deadline, the seller needs to give the buyer the current applicable version of the CREC property disclosure form, and it needs to be completed by the seller not only to their actual knowledge, but it needs to be current as of the date of the contract. So this may not be, a huge concern right now with things selling crazy fast, right? I mean, you put it on the market, you're gonna, probably hold it for a few days over the weekend. And in those 3 days, you're gonna have 20 offers and whatever else, right? So, probably in those 3 days that you had it listed prior to it going under contract, the condition of the property has not substantially changed. And so probably in that case, your seller's property disclosure is fine. However, think back to 2008, 2009, whatever, there were properties that were sitting on the market for 9 months. And in many cases, they were vacant or they had the utilities turned off or whatever. And during that time, right, squatters had gone in and stolen copper out of the property, or the property wasn't winterized, and so the pipes froze and all these other things, right? And so if you had filled out a property disclosure 9 months ago when you first took the listing, but it hadn't gone under contract during that period, and now you get your contract and you give them the property disclosure, it may not be current to the best of the seller's actual knowledge, because there may be things that have happened in that 9-month period. And so then if something comes up after closing, it's almost a green light for the buyer to sue the seller and say, hey, you didn't disclose this, right? You gave us a property disclosure, but it wasn't current actual, it wasn't to the best of your current actual knowledge. And so, it's almost a green light for the buyer to sue your seller for failing to disclose adverse material facts, okay? So honestly, what I do, I don't even do the property disclosure until we get the contract, right? And then I make sure that I have enough time, between the time we go under contract and the seller's property disclosure deadline to get that disclosure to my seller, have the seller look it over, fill it out to the best of their current actual knowledge, and then give it over to the buyer's broker, okay? So again, low risk right now, probably in having them do it right as you're signing the listing contract and all the other addenda and disclosures and whatever else. But just know that if you're going to do that, you need to probably ask them as you're going under contract, hey, these are, you need to review this and make sure that this is current, okay?
Jesse,
Yep.
I have a quick question. I'm
Okay.
from, and I'll just say it, Democratic run states concerning real estate where you can, two things. If you're a renter, you can stop paying your rent and not be evicted. And there's not too much that, local law enforcement can do about it. But the second thing I heard in California, and I don't know if this is going on here, and I just thought I'd pick your brain, that you can literally go to closing, have someone purchase a house, and if the seller doesn't want to sell it, he can remain living in that house I don't even know for how long. And they still have the money and the seller can stay there. And the buyer really, so I'm hearing this from real estate agents in other states where this is actually happening.
Yeah, so a couple things. One is every state does things differently. And so
Right.
What happens in California,
right? But we're a Democratic run state, and that's why I'm asking.
Well, and what I'll tell you is it's again, with every state doing things differently, right? And it's not just the current administration that gets to dictate how real estate operates, okay? And so there may have been a Democrat administration in the past and now it's conservative or vice versa, right? But those laws still remain on the books in many places unless and until they've been repealed or something like that. And so regardless of blue state, red state, purple state, whatever, right? There are many states where the seller, and if you guys saw so it was a huge deal on lab coat agents, right? This article got posted numerous times because some news station did an article on this guy in California. And what happened was, in California, it's very common for a seller to have like 3 days after closing to get out of the property, kind of like what we have, a post-closing occupancy agreement, right? And so what happened was the seller had these 3 days where they were supposed to be moving out of the contract. The seller opted not to move out when they were supposed to within those 3 days. And then the buyer's trying to sue to get the seller out. And the courts in California are like, nope, sorry, we can't kick them out due to COVID and due to tenants' rights and all these other things. And so now these poor buyers, this has been going on for over a year, right? And this could happen in a red state too. It's not tied to red state, blue state, right? This is a thing, and this is something to consider specifically for Colorado, because we do have a post-closing occupancy agreement that takes place in many cases. And it's very difficult. We don't have truly an eviction moratorium, but we do have a de facto moratorium because judges are either so backlogged that it's just not going to happen in any reasonable time. And B, even if you do get your case in front of a judge might look at it and make their own decision of, hey, I'm not going to kick these people out. They don't have another place to go. COVID, whatever, right? We don't know what a judge is going to decide. And so if there is going to be a post-closing occupancy in place, it's just one of those risks that you kind of assume. And hopefully in Colorado, it's not quite as extreme as in California. And hopefully the fact that it's tied to a real estate transaction where the property has sold, right, then hopefully a judge is more lenient and willing to take up your case and get that seller or now tenant out of the property when they're supposed to be. But it's just going to take time to move it through the courts and everything else. And so, certainly it's a risk. I'm not a big fan of post-closing occupancy. If I can avoid it, I will. And what sucks right now is if you have a buyer, like you might just have to do it in order to get your offer accepted. You might just have to do a post-closing occupancy, but you need to advise your buyer about what's going on. Hey, there's a de facto eviction moratorium going on right now. If the seller elects to stay, it may be very difficult to kick them out of the property. Right. And that's the case specifically for Colorado. I don't care what's going on in California or, North Dakota. It doesn't matter what color the state is, like what happens there. It may eventually work its way here, but our laws are our laws. And that's what we need to be aware of. So, yeah, it could definitely be difficult to kick a tenant out of a property. Someone who was a seller who stayed past their post-closing occupancy. And it's just one of those risks that we have to warn the buyers of. You never, as real estate brokers, we always think of everything as, sunshine and rainbows and unicorns, right? And that everything's always going to go perfectly well and smooth. And that a seller who says that they need some post-closing occupancy is going to get out when they're supposed to. But lo and behold, their other deal falls apart that they were trying to buy. They have seller's remorse. They lost their job, so they can't buy a home. Like, what incentive do they have to move right now? They just don't. Okay. So be careful, certainly in the post-closing occupancy, one of the things that you can do is you can have the per diem fee, right? Of, hey, if you stay past your deadline, what's your fee going to be? And like, I received a post-closing occupancy on one of my listings where my sellers got to stay for, is like 47 days is what we needed. And so we get to stay for 47 days for free. There was no, rent due for that 47 days. There was no security deposit, and there was no per diem fee if my sellers fail to leave when they're supposed to, right? Which is great for my sellers. And of course we jumped on that, but if you're a buyer, there's huge risk in doing that. If nothing else, put the per diem fee in there so that you can start stacking up costs against them. Okay. And probably a good idea to get a security deposit in case something gets damaged moving out, so that you don't have to then go try to sue them to get that, because they're not just going to cough it up in most cases. Okay. So know that, understand that. But yeah, it's certainly in Colorado is difficult to get tenants out due to, COVID and the current, call it a de facto moratorium if you want, whatever you want to call it. It's just difficult to kick tenants out of properties right now, even if they're not paying. Okay.
Hey, Jesse.
Yep.
How does that work in the insurance world? Like, what if something happens and they're just squatting basically?
Yeah, good question. So the post-closing occupancy agreement actually, and they just changed it, right, to where there used to be a question that said, is the seller who is becoming the tenant, are they going to get hazard insurance, and are they going to get renter's insurance, right? The renter's insurance are for their own personal contents, right? Their clothes, their computers, their couches, whatever else. Okay. The hazard insurance is the insurance for the property. What happens if the house burns down, hail damage to the roof, right? A car drives through the living room, whatever, right? That's what hazard insurance is for. And so they've just redone that. And the only option that's currently written into the post-closing occupancy agreement asks whether the seller who is becoming the tenant is going to have to get renter's insurance for their contents, right? There is nothing regarding hazard insurance. And so effectively, unless you write something else into the contract, it's going to be the buyer's insurance. It's going to have to take care of any damage, assuming it's something that's covered under the insurance policy. If it's not covered, then there are some things that are stipulated in the post-closing occupancy agreement that says, hey, if this breaks during this period, then the tenant is going to do it. If it breaks if something else breaks during this period, the landlord, who is the buyer, would have to take care of it. So it just depends on what it is, right? There's not a one size fits all answer, but it's all spelled out in that post-closing occupancy agreement. Now, where it gets a little bit gray is what happens if you're after the term of the post-closing occupancy agreement, right? What happens if the seller stays past when they were supposed to stay and then something happens? Well, probably it's going to be the buyer's insurance that's going to have to cover it, right? Seller didn't have, at least the way our contract is currently written, all they have is contents insurance, which protects their stuff. They don't have anything to protect the property. Now, might you be able to go sue the seller, or might your insurance company decide to go sue the seller, for the damage that they caused? Yeah, but that's a headache. Okay.
Okay, thanks.
So yeah, be careful. Again, not a huge fan of post-closing occupancy agreements, but totally realistic in the fact that it's just a part of most transactions right now due to the crazy nature of our market. Okay.
Hey, Jesse, one last question on the post-closing.
Yeah. Yep.
Is that technically a lease? So like getting a deposit and everything like that, we're not supposed to help with leases. Is that correct?
Yes and no. So is it a lease? Technically, yes, it is a short-term lease. Okay. However, it is now a standard form, right? And we do have the right to interpret standard forms, help our clients with regards to standard forms and everything else. What we do need to know is that the post-closing occupancy is not supposed to exceed 60 days. And so if you're going to have a seller who needs 75 days of post-closing, what you can't do is you can't do 60 days worth of post-closing via post-closing occupancy agreement and then, have the parties agree to a 15-day lease outside of that or whatever. If it's over 60 days, they need to have somebody draft up a lease for them, and we're not drafting that lease. Now, we do need to probably have that lease as part of our transaction file, okay? And we do need to have access to it. We can certainly point out any red flags that we see and whatever else, but we're not advising them on it. We're certainly not drafting that for them, right? We can point them to resources that they could go to find a lease, or have an attorney draft one for them or whatever. But yeah, we take a hands-off approach for the most part for a lease longer than 60 days. And if it's going to be shorter than 60 days, they could still go have an attorney drafted up. We don't have to use our form, but we as brokers can't draft that form. They could have their attorneys draft it, or we can draft the post-closing occupancy agreement because it is a standard form. Okay.
Perfect. Thank you.
Yep, you bet. Okay, so 10.2 talks about disclosing adverse material facts. So what it says is that the seller has to disclose any adverse material facts that they actually know about as of the date of the contract. Okay. They also agree that disclosure will be in writing. Now, if you, in your dates and deadlines table, okay, if you go up here, and if the seller's property disclosure deadline is blank or deleted or NA or whatever, right? There's no date in here. What that means is we don't have to we don't have to provide the Colorado Real Estate Commission's version of the seller's property disclosure to the buyer by any particular date and time. However, disclosure of adverse material facts, particularly for a residential property, is a legal requirement which they cannot waive. Now, there are some exceptions to that for things like bank-owned properties, HUD properties, estates, things of that nature, right? That you know, there's very little liability for a bank to say, hey, I just don't know anything about the property. They've never lived there, aside from what they're told, right, or shown in pictures or whatever else. Like they don't know anything more than you're going to know by walking through the property in most cases. Okay. But for a typical seller, even if there is no deadline in our contract, okay, they still have to disclose any adverse material facts that they actually know about, and they have to do it in writing whether it's via email, a handwritten note, which be careful, you got to be able to track it to prove like, hey, yes, we did, right? Whatever it is. So perfect example, I'm closing on a property this afternoon, and the property belongs to my brother-in-law. Okay. So we listed, or when he first purchased the property, you know, we actually had an inspector go out, even though it was a new build. We had an inspector look at it. Everything looked good, right? We close on the property, and literally the day after closing, he comes home from work, and his basement is flooded, and there's water like draining down into his crawl space. Okay. Like, what in the heck is going on here? Well, it turns out that when the home was being built, the builder had, there's these little like brackets that hold the water lines up in the floor joist. And so they nail those little brackets through the floor joist, but they had missed and they accidentally hit the water line, and the water line happened to be PEX, the plastic stuff, right? And that it had just barely nicked it. It hadn't quite gone all the way through, but it was like paper thin. And so it had held on long enough to close. And then literally the day after closing, it had busted through and just was, you know, spraying not a huge stream of water, but for 8 hours while he was at work, right? It was spewing water down through the ceiling on the second in the basement, right? Just destroyed his basement and leaked all down into the crawl space. Fortunately for him, the builder, you know, it was all covered under the builder's warranty. So the builder redid everything, all professionally done. You would never know, but that's still an adverse material fact. And when we put his property on the market, we got an offer where the buyer literally waived everything except for the title deadline. So no inspection, no property disclosure, no insurance, no HOA, nothing, literally waived everything other than the title deadlines, right? But my seller, my brother-in-law in this case, still has a legal obligation to disclose adverse material facts in writing, even though the buyer waived the seller's property disclosure deadline. And so what we had to do is we had to send him an email that said, hey, just so you know, you waived the property disclosure deadline. However, here you go. This is what happened. Here's the paperwork. It was all professionally done by the builder, right? So that way in the future, if it ever comes up, he's talking to the neighbors and the neighbors are like, oh yeah, that place had a huge flood. They had to come fix it, whatever. It's like, dude, we disclosed it to you in writing. We gave you, we told you, okay? This is also important. So if the seller discovers an adverse material fact after the date of the contract, right, then the seller still has to disclose that fact to the buyer. And here's one of those hidden deadlines in our contract. Buyer has the right to terminate based on the seller's new disclosure of that adverse material fact on the earlier of closing or 5 days after the buyer receives notice of the new adverse material fact. Okay. So, if something happens, right? We had a deal with one of our Fort Collins agents where there was a swamp cooler on the roof. And after the seller had moved out, but prior to closing, that swamp cooler had started, leaking, and it was leaking down through the roof into the living room, right? Destroyed the wood floors, drywall was falling from the ceiling. It was bad, right? And just because the buyer was past all of their dates and deadlines doesn't mean that they have no right to terminate. No, now there's some new adverse material fact that has to get disclosed. Buyer can choose to terminate if they so choose. In this case, we were able to work with insurance and get it covered and whatever else. But certainly if something is disclosed to them after, after any dates and deadlines, doesn't matter. There's this 5 days hidden here in section 10.2 that they would have to terminate the contract. Okay.
Another quick question.
Oh, yeah, go ahead.
I don't know all the details or specifics of this situation, but a old colleague of mine, I found out, is being sued because she sold her house and one of the bathroom remodels they did wasn't permitted, and but they've never had any leaks or issues. I don't know if it was cosmetic. I don't know if electrical changes or plumbing changes were done, but the new buyer found out it wasn't permitted for whatever reason and is now suing them, saying it's an adverse material fact. So where is that line drawn?
Well, so good question. So a couple things. One is, if you look in the property disclosure, there's actually a section that says, have any additions or alterations been made to the property, right? And if the sellers did make those additions or alterations to the property and they checked the box, or there's no box now, but if they left that part blank, or if they happen to write in there no, then they're effectively lying on the property disclosure, right? And so is it an adverse material fact or is it not? I mean, if the buyer would have known about it, the buyer is going to claim, yeah, it is an adverse material fact. And if I would have known better, I wouldn't have purchased the property, or I would have required the seller to go do it, right? And so I think it's certainly a valid claim. Now, whether or not it holds up, I don't know. I mean, there's so much to flesh out and figure out regarding any of these circumstances to give a one-size-fits-all answer. But if I was a buyer, I'd be looking for a way to, claim that I had some damages against the seller. And certainly that would be the first place I would go, is what did the property disclosure say? If it said, yeah, it was done, but it wasn't permitted, then buyer probably has no leg to stand on because the seller disclosed it, right? And this is where a lot of sellers are like, well, no, I don't want to fill out this property disclosure. Like, I want to just let it slide and, hope they never figure out, hope nothing ever goes wrong. But really, the opposite is what they really want. They want to be as specific as possible, disclose everything that they possibly know, let the buyer make an informed decision. And then if the buyer closes on it and something happens in relation to whatever got disclosed, how is the buyer going to be pissed about it? I told you, if you chose not to look into it, that's not my problem, but I didn't conceal any adverse material facts, right? So I don't know. I think it's a valid, just on its face, is it valid? Yeah. Now, is there enough evidence to prove anything in court? I don't know. There's a lot of other things that would need to be figured out too, right? Looking at the contract, property disclosure, everything else. But I would think it's at least a valid starting point.
Okay, thanks.
Okay. Yep. Okay. So this last piece in here, right? Effectively what 10.2 says is that except as otherwise provided in this contract, meaning unless we state something else somewhere else in the contract, the buyer is purchasing the property in as is condition, where is, and with all faults. Now, a lot of trash gets written down into additional provisions regarding inspection stuff. And most of it means almost nothing with respect to what the broker actually thinks that it means. So let me, give me a second. I'm going to pull something up. I should have had this up to begin with today, but we will we'll watch a little video from a guy by the name of John Goodman. John Goodman is a real estate attorney in the state of Colorado, very high level attorney. He works for Frascona's office, which is one of the premier, real estate attorney brokerage firms or whatever. And so we'll watch this. Give me just a second here. Figure out how to share this. Share sound. Okay.
Hi, this is John Goodman. Today we are talking about what the phrase "as is" means in a contract.
So real quick, can you guys hear the sound coming from YouTube? Can you guys hear that okay? Anybody?
Yeah, we can hear it, Jesse.
Okay, cool. Just want to make sure. Sometimes the sound doesn't come through, so.
Now, unlike the phrase "earnest money going hard," which we talked about in the last webcast, that phrase "earnest money going hard" doesn't have any meaning. The phrase "as is" actually does have meaning, but it doesn't mean what most people think it means. Some people think that the phrase "as is" means that the seller is not obligated to disclose anything about the property, that it relieves the seller from disclosing adverse problems, latent material defects that the seller is aware of regarding the property. That is not what "as is" means. And in Colorado, for example, in residential real estate transactions, it's pretty clear that a seller cannot contract away the seller's obligations to disclose latent material defects of which they're aware of. Perhaps in commercial real estate transactions they can, but not in transactions that are primarily not in transactions where the seller is primarily selling property that is for household use. Okay, some people think "as is" means that it takes away the buyer's inspection rights to inspect the property. No, that's not what it means. And if that's what the seller is intending, then there should be an explicit provision taking away the buyer's inspection rights under a contract. Some sellers think that it means that the seller does not have an obligation to make any repairs in response to any of the buyer's due diligence objections. No, that's not what that phrase means. And it's unnecessary because most contracts do not have provisions in them that require the seller to address buyer's due diligence objections. Some sellers think it just means that the buyer can object based on their due diligence objections. In Colorado, what we would call an inspection objection. The buyer can object, but the seller is signaling that it's not going to make any repairs. Well, the seller can signal that outside of the contract. That doesn't have to be language inside the contract. That's not what "as is" means. So, what does "as is" mean? What does "as is" mean? All "as is" means is that it's the seller is disclaiming any implied warranties about the property. The seller is not warranting the property, for example, that the property can be used for the buyer's intended purpose. It's also a phrase that means that between the buyer and the seller, the buyer bears the risk of any latent defects in the property that the seller was not aware of. That's all "as is" means. It doesn't do any good for a seller to add it to the Colorado contract because the Colorado state approved contract has "as is" pre-printed in it.
Okay, so as is, it doesn't need to be written into additional provisions because there's already, it's already written into 10.2 that not only is the property being sold as is, but it also is being sold where is and with all faults. And as is doesn't mean what most brokers thinks it means anyway, right? And so all these clauses that you see in additional provisions, right, that say, oh, buyer acknowledges the buyer's purchasing the property in as is condition. Well, does that mean that they're not purchasing it where is and with all faults as mentioned in 10.2? Because now you have 10.2 that says as is, where is, and with all faults, and then additional provision says only as is, right? That conflicts. So which is it, right? And it doesn't, it's already written elsewhere, and it doesn't mean what they think it means anyway. And so what the Real Estate Commission did, because they realized that agents were doing this thinking that they were being smart and thinking that they were trying to get a competitive edge, right? What they did was they added an inspection termination deadline in our dates and deadlines. So it used to only be an inspection objection and an inspection resolution. And what they've done now is they've said, okay, if what you were planning on trying to convey was that the buyer was going to purchase the property as is, meaning they weren't going to ask the seller for any repairs, but they only wanted to preserve the right to terminate, then let's add this inspection termination, okay? And if if that's what you were signaling, then what you could do is you could waive your inspection objection, waive your inspection resolution, because you don't need a resolution if there is no objection, but preserve your termination by having a date for your termination here, right? So today's, March 30th. So maybe you have April 9th as your inspection termination, and you waive your objection in your resolution. You put NA or deleted, or you leave those two blank and just have April 9th for your inspection termination, right? And effectively what you're saying is the buyer has no right to ask the seller for repairs. However, if there's something that's bad enough in that inspection, then they preserve their right to be able to terminate and get their earnest money back. Okay. And then you don't need to address anything in additional provisions because, the other iterations of this stupid clause that brokers were writing would, even if it didn't mention as is, right? They would say, oh, the buyer has the right to object only to health and safety items, right? Or structural or whatever it was. Okay. Well, the problem with that is, what is a health or a safety item? Who gets to define that? Where is that defined in our contract?
Nowhere. It's totally subjective.
Nowhere. Yep, totally subjective, right? And so, again, I use this example not to poke fun or, be insensitive, okay? It's a real thing that has come up. But, seller or, buyer goes under contract on a home, right? And they love it. And they say, oh, we're only going to object to health or safety items. And then after they go under contract, the buyer's child commits suicide. Okay. And then turns out that the room that was going to be their child's room in the new house was painted blue, just like the child's room was painted blue in their current home. Right. And they go, oh my gosh, I can't move into the new home because, that room would just remind me too much of our kid's room. And that's causing me emotional distress. It is absolutely a health thing. It will make me go into depression or whatever. Like, who's to say that that's not a health issue? Right? It's not defined in our contract. And so it's entirely subjective as to who gets to decide what's health and safety, what is a structural issue, right? You might have a crack in your foundation wall, but it doesn't have any adverse effect on the property, according to, one structural engineer that you hired, right? So is that a structural issue or is it not? I don't know. It's not defined anywhere. Okay. So you can just avoid additional provisions altogether if that's what your goal is, by putting an inspection termination deadline in here and waiving the objection, waiving the resolution. Okay. Now you have to be a little bit careful. This isn't like a foolproof, we're getting out of this thing, free and clear, because what could happen is they waive that objection, they waive the resolution, they keep a termination deadline in there, right? And they do their inspection, and lo and behold, there's a leak at the kitchen faucet, right? And they're like, hey, Angela, really sorry, but my buyer's really just not thrilled about this leak at the kitchen faucet, so we're going to terminate. But if you guys want to fix it, like, they'll move forward, but we preserved our right to terminate, and they don't like that, so we're going to go ahead and terminate. But I'll wait until you talk to your sellers about it before I send you the actual notice to terminate. So let me know what they want to do. Is it worth it for your sellers to replace the leaky kitchen faucet to keep the deal moving forward? I mean, in most transactions, probably yes, right? Now, maybe if I've got a backup offer that's $10,000 better than Angela's or whatever, I go, hey, okay, yeah, we'd really just prefer to let this thing terminate. So if your buyers want out, then go ahead and send us over the notice to terminate, right? And you think that we're calling your bluff and everything else. So you send over the notice to terminate thinking, oh, we didn't realize you guys were actually going to terminate, and you think we're going to come back to you and try to put the deal back together. And lo and behold, no, I have this backup offer that I never told you about, right? And now you're hosed. Your clients have no way to get back into the deal because you terminated. I moved into, under contract with backup offer, buyer number 2, and you're gone. Okay. But in many cases, they could still come at you and say, hey, yeah, sorry, radon's high, and we're going to terminate if your sellers aren't going to do it. Is it worth it? I don't know. I mean, what is it worth it for the sellers to keep the deal alive and keep the deal moving forward? So there may still be some negotiation. There may still be some give and take, right? But the way that we avoid all the confusion and the fact that, there's contradictory terms in 10.2 and additional provisions is we preserve our inspection termination, we waive our objection, we waive our resolution if that's what you want to do. Buyers certainly don't have to waive their objection and resolution. They can keep it, but that's why they added that inspection termination deadline, was so that we could just skip additional provisions altogether, not be confused by what's written in there, not have any subjectivity with regards to the terms and all that other crap. Okay. All right. 10.3. Oh yeah, go ahead.
Sorry. How do you navigate? So your buyers are interested in a listing, and the listing agent has told you, when submitting an offer, make sure you put in that inspection is only due to health and safety. Like, how do you talk to that agent and rebuttal that to get your buyer to present the best offer, knowing that what they're asking for is completely bogus?
Yeah, good question. So honestly, in some cases, you're just going to have to do some education, right? And say, I'll do you one better, Brandy. My client's not even going to object to health and safety items. My client is only going to take the property truly as is, or they're going to terminate if it's bad enough, right? And if it's because it's something that's bad enough, we'll give you notice first, but we're not even going to ask for health or safety items. We're going to truly take it as it sits today, unless there's just something so glaring, so wrong that my client is just not comfortable with it. And then they will terminate, but we're not going to object, right? And send them John Goodman's video, right? I could put all the verbiage and crap that I want in additional provisions. And at the end of the day, it doesn't mean what you think it means, right? And if health and safety is truly what you want to see in this contract, then you're leaving a lot of subjectivity there, right? And maybe my client tries to claim this is health related or this is safety related, and you have no way to refute that because there's no objective standard by which to determine whether those items are health or safety, right? I'm getting rid of all of the subjectivity, and I'm just telling you we're not objecting to anything. We're going to take it or we're going to leave it, right? If they want to see that in the offer and that's what gets the offer accepted, right? Then have the discussion with your buyer that, hey, this is what they want. This doesn't mean what they think it means, right? We may have the best chance of getting your offer accepted if we put something in there, but I want you to know that it doesn't mean what you think it means and what they think it means, right? Have the conversation with your buyer, advise your buyer, and do it in writing so that if they try to come back later and say, Brandy, you didn't tell me that I couldn't object to this or that, or I had a right to object to this, right? Put it in writing so that it's there so that they can't turn back against you later. Okay. And then if that's what they want to do, if that's what they've advised you to do, because they want the best chance of getting their offer accepted, and the listing broker who's been in the business for 25 years, who knows everything there is to know, but they don't have any clue what they're actually doing, if that's what they want to see, then do it. But know that you're likely to open up a can of worms when it gets down to inspection stuff. If you object to something that you believe is related to health or safety, and they say, no, it's not, right? Who's the judge? The judge is the judge, not us, not the sellers. So you're putting your clients in a position of risk by doing that. Okay.
Thank you.
Yep. 10.3 talks about the inspection. So again, unless otherwise provided in contract, buyer acting in good faith has it. And, again, that means that we have to terminate for what we say we're terminating for. We can't just say, hey, there's a house down the street, but we have our inspection objection or our inspection termination deadline. So we're just going to use that and then bail on this property and go buy the one down the street. That's bad faith. Okay. So buyer acting in good faith has the right to have inspections on the property, right? Of the property and the inclusions. Okay. So it doesn't have to be the real estate. It could be the personal property as well. Obviously it's at the buyer's expense. And then I hate that it gives this enumerated list. Okay. Because it says if any of these things are unacceptable to the buyer and the buyer's sole subjective discretion, the buyer can object, they can terminate, whatever, right? As long as that section applies. And so what the list says, right, the enumerated list says, 1, the physical condition of the property, including roof, wall, structural integrity of the property, which it's already listed right here, right? Again, going down, writing it back in additional provisions, who knows? The electrical, plumbing, HVAC, other mechanical systems on the property. So that's number 1. 2, the physical condition of the inclusion. So if the fridge doesn't work and that was a big piece for your buyers and they don't have money for, a new fridge, then they can terminate based on the fridge, even though it's not part of the real property. Okay. Service to the property, including any utilities, communications, right? Whatever. If the home doesn't have internet and you thought it had high-speed internet, then buyer could terminate if there's no way to get internet. Okay. Whatever utilities, you thought it was, you thought a water tap was available, but lo and behold, it's well and septic and your client doesn't want that, they can terminate. Okay. Along with any other systems or components of the mechanical systems, heating, plumbing, all that other stuff. Okay. 4 says any proposed or existing transportation project, road, street, or highway. So if, you go under contract and they find out, CDOT's going to widen the highway and that's going to get closer to my property, well, then they can terminate based on the proposed. It doesn't have to be in the works, but if it's proposed and they find out about it, then they have a right to terminate. Or any other activity, odor, or noise, whether it's on the property or not, and it's an expected effect on the property, its occupants, if any of that stuff is unsatisfactory in the buyer's sole subjective discretion, then they can do any one of these things, right? They can object before the objection deadline if that deadline applies. If that deadline doesn't apply, then they have no right to object, right? If you've preserved your right to terminate, then that may be your only option is to terminate. But certainly before you send that termination over, you might ask the listing broker, hey, we're going to terminate because the furnace is crap and it needs to be replaced. Does the seller want to do it for us or do they want to put it back on the market and probably still have to do it for somebody else? Okay. Obviously, if there is an objection that the buyer delivers to the seller, then there needs to be a written agreement on or before that inspection resolution deadline, or buyer can withdraw their inspection objection, or the deal will terminate, right? So just like our other contingencies, if there is no resolution by the resolution deadline, again, it doesn't mean that the work has to be complete, but there has to be a written agreement as to what's going to be done by that inspection resolution deadline. Okay. Now, what I will say is in the inspection resolution, there's a date that says on or before whatever, date, the work needs to be complete. Probably not the best idea to have that date be the same day as your closing, right? Closing's at 4 o'clock today, right? And you're like, oh, I'll go do my final walkthrough this morning at 10. Well, you go do your final walkthrough this morning at 10 and you have appointments throughout the afternoon and whatever else, and the work isn't done yet. And they're like, oh, hey, Harry, don't worry about it. We're going to get it done prior to closing, right? And you're like, okay, well, do I take your word for it? Because, I can't cancel these other appointments that I have this afternoon, and I'm not going to have a chance to go back and verify that the work was complete before closing. So do we sign closing papers and assume that it was good? Or, do I try to cancel my other appointments? Do I send the buyer over there by themselves? I don't know, right? Don't squeeze yourself that tight. Make the date by which that work is supposed to be done, maybe like a week prior to closing. So that way you can, go check it out, well in advance of your final walkthrough. Go check it out, make sure that it's done. And if it's not done, then now you at least have a week to start making some other plans if it's not going to get done, right? Cancel your truck, your moving truck, or what, at least you've got a little bit of time instead of trying to scramble at the last minute to change all your plans.
So Jesse, let's say you get an inspection and there's something major that has to be done and the seller's willing to do it, but it won't get done until it's going to take 4 weeks and you close in 3.
Yeah. So the roof is going to be typically the one that always comes up, right? Seller says, hey, I'll do the roof, but between the roofer's schedule and, the insurance company's payment schedule and having my bank sign off on all this stuff, it's not going to be done until after closing, right? So that's okay. If you actually look at the inspection objection or the inspection resolution rather, what it says on there is if the work is agreed between the buyer and seller, if they agree that the work will be completed after closing, then the work will survive closing. Okay. That doesn't mean that everything on the inspection resolution survives closing. If it was supposed to get done prior to closing, and then the buyer closes on the property, the buyer has accepted the condition. Okay. And they don't get to go back to the seller. Now you can certainly try, but from a legal perspective, they don't get to go back to the seller and say, hey, you didn't do this and it was supposed to be done prior to closing. Well, you closed on the property. You signed off on its condition, right? And that's why it's important to have a bit of a buffer, because what your clients don't want to do is now they feel like they're in a hard spot because you're doing your walkthrough an hour before closing and the stuff isn't done. What are they supposed to do now? They have no time to change plans and everything else. So either they sign and accept the condition of the property and have nothing to show for it, or they absolutely screw up all their other plans and they have to rent their truck for another week or whatever else, right? It just gets ugly.
That's not in the original contract. It's in the resolution. Is that what you said?
In the resolution is where it says, if the buyer and seller agree that the work will be completed after closing, then it will survive closing. And so you need to be clear in your resolution, right? Okay. That the roof replacement will be done after closing, and this provision in the resolution will survive the closing. Okay. Now, so there's some other sections that down in 19 that address some other stuff relating to insurance, right? So we'll talk about that when we get there. But just from from an inspection resolution perspective, what you need to know is the stuff on the inspection resolution doesn't survive closing unless it's agreed that the work will take place after closing.
And if there's money tied to that, that's also part of the closing.
So we'll talk a little bit more about that when we get to section 19. Okay. Because we may have to escrow money. We may have to escrow 1.5 times. So we'll talk about that more in 19. Okay. Let's see, damage liens and indemnity. So, buyer is responsible for payment of all their inspections, test surveys, all the other, any other work that the buyer requests to be done. And they have to pay for any damage that occurs to the property and the inclusions. as a result of that work. And so, might sound crazy to you, but we actually had a transaction at our Fort Collins office, and it wasn't really the inspector. The builder had come out to do some work based on the buyer's inspection objection, right? And this was a new home that was still under warranty, but the seller had to sell like right away. So the seller was only in the house for like 6 months, and it was still under the builder's warranty. So the builder, sends out one of their workers, and he actually fell through the ceiling. He was up in the attic, and he stepped off of a floor joist or slipped off of a floor joist or whatever, and he fell through huge gaping hole in one of the bedrooms, right, and damaged the closet on the way down, the door on the closet on the way down. So in that case, it's a little bit different because the seller actually hired the builder through the warranty, right? But if that was the inspector as opposed to the builder's warranty, if the inspector had done that, right, then technically the buyer is on the hook for that damage. Sounds a little bit crazy, right? And you're like, hopefully the inspector had insurance and is going to fix it. And certainly that's an important thing to talk about with your inspectors, is, hey, are you bonded, insured, whatever? And the hope is that they would, but if they go, hey, I'm sorry, now I'm in the hospital, I broke my back and I have to save all my money for medical bills, so I'm not going to be able to pay it. Well, guess who's on the hook for it? Even if the buyer chooses to terminate, the buyer is still on the hook for it because the provisions in this section survive the termination of the contract. Okay, so just know that if the inspector or someone damages the property based on work that the buyer asked to be performed, then it's the buyer's responsibility. Okay. And that includes any, legal fees that the seller incurs to defend, against liability, damage costs, all that other stuff. And that adds up quick. So be careful, use inspectors and contractors that are insured and everything else. Okay. Insurance, we talked about insurance a little bit. Guys, this is one you don't want to miss. Like, you don't want to let this deadline go by. You think it's no big deal. Oh yeah, we can for sure get insurance on the property, everything else. And what I'll tell you is there are some areas where the FEMA flood maps are different than maybe the county's flood maps. And so you might go to one flood map and go, oh yeah, we're not in a flood zone, no problem. Right? You're going to be able to get insurance on this or whatever. And so you either waive it or you let that deadline go by without checking in on your buyers. Like, hey, have you, made sure that you can get a reasonable quote for insurance on this? At least check in with them, right? Don't let it go by. This became a huge issue, not only for flood insurance, but with the fires that we had, there were many areas where buyers couldn't get insurance, period, due to fire damage, right? And then what's the concern after a property, or what's the concern after a forest burns, right? Not just fire, but now you're dealing with potential mudslides. And this is why insurance companies didn't want to touch anything that's up in the burn scars. And many of them still won't, right? So make sure that you don't just let that deadline go by. It doesn't mean that the buyer has to have insurance by the property insurance termination deadline. It just means that they have to be comfortable with the fact that they can get a reasonable quote in their sole subjective discretion. Okay. Due diligence documents. So a couple things. One is, if you're going to ask for due diligence documents, first of all, you need to check the appropriate box, because if you don't check the box, but you list a bunch of stuff here, right? What does our contract say up above about the applicability of a section that doesn't have the box checked? It says that it's not applicable, right? So if you don't check the box, but you list a bunch of documents here, does it mean that it's not applicable? Well, I don't know. It doesn't make sense the way that you wrote it. So first of all, if you're going to ask for due diligence documents, then check the box. Secondly, if you're going to ask for them, then in your dates and deadlines, you need to have due diligence documents deadlines. Because if you have no right to terminate based on these things, then why are you asking for the documents in the first place? I mean, maybe just for informational purposes, okay. But if your buyer wants to have a right to terminate based on something in the due diligence documents, then you need to check the boxes here, and you need to add a deadline up above. The reverse is also true. If you're not going to ask for any due diligence documents, there's no reason to have due diligence documents deadlines in your contract. Okay? You're not asking for anything. You have nothing to object to, right? So you don't need the deadlines in your contract if you're not asking for anything. The other thing I'll say about due diligence documents is that you don't, if it's not something that your buyer would ever object to, you really don't need to list that stuff here, right? We always see brokers put stuff in here about the manuals and the warranties for the appliances and all this other stuff. Like, how many of your buyers are actually going to go through and read the, owner's manual for the fridge from 1987 that's still in the kitchen and object to the fact that, they don't like whatever it said in the owner's manual? If your buyer's not going to object to it, then don't put it in there, right? Certainly if there's leases associated with a property, then you need to get those as part of your file. You need to make sure that your client's looking at those leases, that they have enough time to have those leases reviewed by an attorney or by themselves, if nothing else, right? But again, not really your job to interpret a lease, which is not a standard lease, okay? And there is no standard lease other than that short-term post-closing occupancy agreement of less than 60 days. So any other leases that are in place on a property, you're advising them to review it, right? Advising them to seek legal help if they have questions about it, but you're not the one who's interpreting the terms of that lease, okay?
So Jesse, if they have a
Yep.
propane tank and it is not owned, it is leased?
Yep.
Okay.
Yeah, you could certainly list that here, right? You
Right.
may also want to put something down in the proration section to say that the fuel, the propane and the propane tank will be prorated as of the day of closing, right? But yeah, you could certainly put that stuff here. What does that lease look like? Yep, that would be, 10.6.1.1, right? That's where this would go.
Hey, Jesse.
Yep.
Going back to my solar issue, since they were owned, they had a loan out for it. Should 10.6.1.1 been checked?
Well, since they're owned, right, it's not a leased system,
Right.
If, and there's some confusion here because you can have an owned system that you're making payments on, right?
Right.
If that's the case, there is no lease. And so those don't go into 10.6.1.1,
Okay.
right? Those need to be addressed elsewhere in the contract. And, that doesn't mean that the buyer can't assume the payments of that solar loan, right? For an owned system. Certainly they can. It's just, it doesn't go in 10.6.1.1 because the panels aren't leased. It's not a solar lease. It's a solar loan. And there is a difference between the two.
Right. Okay.
Okay.
Thanks.
Yep. Okay. So buyer, obviously, again, assuming you have those deadlines up in your dates and deadlines table, the buyer has a right to review any of those due diligence documents. If they are not supplied to your buyer or if they're unsatisfactory, then buyer can, do a notice to terminate, right? Say, hey, we didn't get the documents, or we got the documents and they're not satisfactory in our sole subjective discretion, so we're going to terminate. They can object to whatever, documents have been delivered and give the seller a written description of what's unsatisfactory to them. And then again, just like any of our other ones, if the buyer does object, then you need to have a written resolution by that resolution deadline. Doesn't mean the work needs to be complete. But if you don't, the contract will terminate unless the buyer withdraws their objection. Okay. Okay, conditional upon the sale of property. So if your buyer needs to sell a home first, good luck in this market, but this is where you would put the address of the property that they need to sell, okay, in order for this contract to close, right? And you need to watch this deadline like a hawk, your conditional sale deadline, because if you let that go by and then their contract doesn't close for whatever reason, they have no right to terminate this contract if this is why they can't purchase this property, okay? again, does it happen where, you know, you might, in order to look aggressive, right, you put a 7-day conditional sale deadline because you don't want to leave it hanging all the way out there for closing because you have to be aggressive because of multiple offers, right? So you put a 7-day conditional sale deadline, you let that 7 days go by, and then your buyer's, you know, home, or your client's home that they are selling, that deal falls apart. So they can't purchase this home, right? Are there ways that you could potentially get out of this contract? Yeah, you might still have inspection deadlines and loan deadlines and everything else, but if you use that, your buyer in this case is operating in bad faith. Their earnest money's at risk, right? So if they don't want to put their earnest money at risk, then don't let this deadline go by unless and until you've closed on their conditional sale property. So the best situation for the buyer, you know, the person who is purchasing this property but has to sell this conditional sale property, the best thing for them is to have this conditional sale deadline be the same day that you're closing on this property. Okay. Now the seller might not want that, right? The seller doesn't want a conditional sale deadline at all. They would prefer it be non-existent, or if nothing else, they might prefer that it be 7 days or 10 days into the contract or whatever. Okay. So realize that buyer and seller are on opposite ends of the spectrum here. Negotiate it, figure out where, you know, where the parties are comfortable accepting it. In a down market, most buyers can push a conditional sale date all the way out to the same day that you're closing on this property.
But in today's marketplace, this would probably be a deal breaker, right?
Yeah, today's market, you put 1 day in there and you're toast.
Yeah.
I mean, not 100% true, but generally speaking,
Close.
like, you're not competitive if you have to sell a property, right?
Yeah.
So that's rough. So the other piece that you got to be aware of is if you go, okay, well, in order to be competitive in a multiple offer situation, I'm just going to waive my conditional sale deadline because I know that we can get their property under contract and sold. Well, do you really know that? I mean, yeah, you can probably get it under contract relatively quickly, but what happens if the buyer on that deal dies the day before closing? You're going to be able to close on this one?
Nope.
Nope. And guess what? That's what's called an adverse material fact. And what do we know about adverse material facts? What's your obligation with regard to adverse material facts?
You have to
divulge it.
Yeah.
Yeah, you have to disclose it, and you have to disclose it in writing. Okay. So it's possible, hang on, it's possible to waive your conditional sale deadline. In other words, you don't put it in the contract, right? But you still need to tell the other broker, maybe via email, hey, just so you know, we've waived our conditional sale deadline. My buyer does have a property that they have to sell, but it's already on the market. It's already under contract, right? We don't see any hurdles getting to closing. And your buyer needs to know if they do that and then their property doesn't sell for whatever reason, their earnest money is at risk here. Okay. So that needs to be disclosed in writing. Don't forget the in writing part. It needs to be disclosed in writing because it is an adverse material fact about your buyer's financial position. And trying to conceal it by waiving the conditional sale deadline is concealing an adverse material fact. And that's one of the biggest reasons that brokers get popped. Okay. Harry, did that answer your question already?
Yes, thanks.
Okay. Let's see. This all makes sense. The section is for the sole benefit of the buyer. Seller doesn't receive the buyer's notice to terminate, then the buyer waives the right to terminate. Okay, that all makes sense. Source of water. So either the buyer does or does not acknowledge receipt of the seller's property disclosure or the source of water addendum disclosing source of potable water. So in many cases, the listing broker doesn't provide a source of water. They say, oh, it's in the seller's property disclosure. Well, you go to the seller's property disclosure and you look at the section that deals with the water and it just says public. Well, does that tell you who the water provider is? No. right? So we need to have in our file somewhere, whether it is the property disclosure actually disclosing who the water provider is, or we need to have a source of water addendum disclosing who the water provider is, not just public or city or whatever, right? Put the information in there, right? Get the address, the phone number, the website, fill out the information completely so that the buyer doesn't try to come back and say, hey, you didn't tell me who the water provider was, right? You said public, and it's not really public. It's the Fort Collins Loveland Water District, which is a private corporation or whatever, right? Just do your job and fill it out completely, okay? In most cases, there's not going to be a well, so we can check this box. Or if there is a well, then buyer does or does not acknowledge receipt of a copy of the current well permit. Again, even if the seller doesn't have a well permit, if they have the well number, it at least, or the permit number, it at least helps you a little bit when trying to find it through the Division of Water Resources, which is the website that you can go to look these things up. It's just not a very user-friendly website. It's a little better now than it used to be, but not super friendly. So if you can at least get the permit number, the well permit number, and it will make your lives a little bit easier, okay? Obviously, there's the note to the buyer, right? Well, some water providers rely on, sources of non-renewable groundwater. If you're worried about it, then go contact the water provider, okay? This part was deleted because this got moved into the income contract. 10.10, lead-based paint. So again, lead-based paint operates a little bit differently in Colorado than it used to. It used to be that if you did not have a lead-based paint disclosure that was fully complete and executed by all parties, including the brokers, if you didn't have that prior to signing the contract was void, not voidable. It was void, meaning it was dead. It was as if it never existed. Okay. And then buyer and seller, not realizing that, they would get, 3/4 of the way through the deal, and then seller gets a backup offer and they go, hey, we'd really love this backup offer because it's an extra $15,000. Turns out we didn't actually sign that lead-based paint disclosure before the offer. We signed it afterwards, or we never actually signed it, right? And so then the listing broker was telling the seller, like, hey, we can just get, that first offer is void. It's as if it never existed. So yeah, let's just accept this backup offer, okay? And while that sounds all fine and good, and that makes it sound like, or at least at the time, the way our contract was written, made it sound like that was a viable option. Effectively, the courts held otherwise and said, no, even though you had a void contract, you were operating under what's called an implied contract, right? And so the buyer still has rights under this implied contract, and the seller still had obligations under this implied contract. And so now they've changed it. They've said, really the best practice is still if a building permit was issued prior to January 1, 1978, not if the house was built. If a building permit was issued prior to January 1, 1978, then we need to have that lead-based paint disclosure. But now they've added this piece. If the buyer does not timely receive that lead-based paint disclosure, they can waive the failure to timely receive it from the seller, or they can exercise their right to terminate by sending a notice to terminate on or before that lead-based paint termination deadline, okay? And if they choose to go past that deadline, the contract doesn't automatically die. It doesn't become void, right? We don't want people operating under void or implied contracts. We want actual contracts. So that's why this all changed. And the best practice is still do it right up front, guys. Don't wait until after these deadlines. There are still stiff penalties for sellers who are not giving buyers these lead-based paint disclosures, all this stuff, right? So still just do it up front, and that's the best practice, okay? If the buyer does choose to do a lead-based paint test, then they have a right to terminate on or before that termination deadline. If the notice to terminate would otherwise have to be received by the seller after closing, then the buyer needs to do it on or before closing. They can't close on the property and then say, oh, hey, you know what? changed our minds. It has lead-based paint. We don't want it. Take it back. No, needs to be done before closing. Okay. In the lead-based paint disclosure, there's actually a checkbox that says either buyer chooses to get a lead-based paint assessment or they decline, right? And even if they check the box that says, yes, I want to get a lead-based paint test, well, they have a right to waive that requirement. It doesn't mean that they have to do it, but they certainly have the option if they check that box, okay? If the seller doesn't receive buyer's notice to terminate within that time, the buyer accepts the condition of the property relative to lead-based paint, okay? All right, carbon monoxide alarm. So there is a difference between Colorado law and building code, okay? So smoke detectors are part of building code. Carbon monoxide alarms are actually part of Colorado's law. Our statutes require carbon monoxide alarms in properties. Okay, so not all properties, there might be some exceptions. So what this says is that if the improvements on the property have a fuel-fired heater or appliance, meaning they have a fuel-fired furnace, fuel-fired water heater, a boiler, a gas clothes dryer, right? Whatever it is, okay, any fuel-fired heater or appliance, if it has a fireplace, or if it has an attached garage. So any one of those three things, and if it includes one or more rooms lawfully used for sleeping purposes, i.e. a bedroom, then there have to be carbon monoxide alarms within 15 feet of the entrance to any bedroom per Colorado law, okay? Or in a location that may be otherwise required by building code. So know the difference between code and Colorado law or statutes, right? Our statutes say that it has to. That's Colorado law. The smoke detectors, that's building code, okay? All right, meth. So meth is a fun one. If the seller knows that meth was ever manufactured, processed, cooked, disposed of, or used or stored at the property. So this is not just like if it was manufactured. If the seller has a meth habit and they use it, but they've never manufactured it, guess what? Still have to disclose if they know that it has ever been used at the property or stored at the property. It doesn't even have to be used there. If it was stored there, seller has to disclose, okay? However, there is no disclosure required if the property was remediated in accordance with state standards and other requirements are fulfilled pursuant to, this is Colorado revised statutes, right? So if you go look at that statute, it tells you what those requirements are, okay? Now, the big issue right now, okay, one of the big legal hot topics right now is that if you actually go read Colorado revised statute 25-18.5-102, it makes it clear that a seller is not required to disclose the fact that that meth was manufactured, processed, cooked, disposed of, or used at the property if it has been remediated in accordance with state standards or other requirements. However, it does not provide the same protection to brokers, real estate brokers. So you may have a property that has been remediated in accordance with state standards, and you may still be liable if you choose not to disclose the fact that it was at one time used, processed, cooked, manufactured, whatever. How many of you want to be on the receiving end of a lawsuit where a buyer comes after you claiming that you failed to disclose the fact that the property was at one time used for meth?
So are you saying the best thing is to disclose it, say it was fixed and leave it at that, and then it's up to the buyers after that?
Yep. And really what you got to be careful of is your seller needs to be aware of that as well, right? If your seller says, Harry, no, you're not allowed to disclose, then you're in a tough spot. You either say, okay, fine, I'm not going to disclose. I'm going to keep it to myself, which I would just say 99% of the time, you're going to get sued. Okay. Or you can go to the seller and say, listen, I'm not offered the same protection under the law that you are. I have to disclose, and I have to disclose it in writing. So I have to disclose to the buyers, right? And if they say no, then okay, then I need to terminate because I'm not taking on a lawsuit, right? One commission is not worth what you're going to pay in legal expenses and everything else for failing to disclose an adverse material fact about the property. And I don't know, I haven't done any scientific polling, but I would say probably 100% of the buyers who purchase a property that was at once used as a meth lab or smoked or whatever will tell you that it's an adverse material fact when they find out about it. Okay. So disclose, disclose, disclose. If your seller doesn't want you to disclose, then I don't want you to take that listing. Okay. We had a deal where there was a house in Windsor, and this was prior to the, RE Colorado and Iris having their data sharing agreement. This is when they were fighting. And so they were not sharing data. And there was a broker out of the Denver area who happened to be with a Keller Williams office in Denver. And he had contacted a seller in Windsor and had listed her home in RE Colorado, but it wasn't showing up in Iris. Okay. Because they didn't have the data sharing agreement, and they just weren't getting a lot of traction at the time. They weren't getting a lot of activity, and so this guy calls up one of our brokers and says, "Hey, I got this property. It's in Windsor. It needs a little bit of work, and I'd like to co-list it with you so that we can get it in Iris, and hopefully that way it gets exposed to more brokers in Northern Colorado, right?" And she goes, "Okay, that's fine." And so our broker talks to the seller. Right. And the seller happens to be a landlord, and the tenant was the seller's daughter. And so the seller, the owner of the property, said, "Yeah, I know my daughter's addicted to drugs, illegal drugs, and I know she's been hooked on meth before. I don't know if she's currently on meth or just heroin, or I don't know what the best way to other illegal drugs, right? But at some point she was addicted to meth. And I don't know. I don't have any proof that she ever did it in the house, so I don't want to disclose." So now you're in our broker situation. You have no proof. Is it an adverse material fact?
Because I know that, I would still tell it.
Okay. Anybody disagree?
I'd say it's better just to cover yourself and disclose it regardless.
Yep.
In writing.
Yeah.
Yep.
If someone is addicted to meth, guys, they're probably using it in the house. I mean, is it truly an adverse material fact?
I don't know, but
Maybe not under the legal definition, but 100% guarantee you're going to get sued for this, right? And the best thing to do, guys, is disclose, disclose, disclose. And so in this case, our broker elected not to take that listing because the lady didn't want to disclose. And we kind of had to notify the listing or the employing broker down at the Denver office, say, "Hey, here's what's going on, man." And so he forced his agent to withdraw the listing, right? Like, go work with another broker if you're not going to be willing to disclose it. We're not going to take on that kind of liability. Again, like 100% chance you get sued on that deal. Okay. And the worst part, and what really pisses me off, guys, is that when attorneys get involved, you know what they're going to do? They're going to, seller's going to get sued as part of this deal, right? For failing to disclose. So seller's going to go get an attorney. You know what that attorney is going to do? They're going to advise the seller to say, "Yeah, I told Harry about this. He told me I didn't have to say anything because it wasn't an adverse material fact," right? And then you have nothing in writing. You have nothing to show, right, that you actually disclosed it. You have nothing that shows that you did or didn't advise them to do it. But now it's their word against yours. Okay. So not a good spot to be in. Disclose, disclose, disclose. It's just, in this particular situation, right, it is worth disclosing so that a buyer doesn't, move into the property unknowing, they've got little kids, and now their little kids have, defects or, health issues or whatever it is. Okay. It's just serious enough that you're going to want to disclose. Buyer further acknowledges they have a right to engage a certified hygienist or industrial hygienist to test whether it's ever been used as a meth lab, or again, even if it's only been used at the property, that will still typically show up if you have a hygienist come out and test the property. Okay. Buyer can terminate. This is one of those hidden deadlines there because there is no deadline associated with this. Buyer can terminate upon the seller's receipt of buyer's written notice to terminate, notwithstanding any other provision in the contract, based on the buyer's test results that indicate the property is contaminated with meth, but has not been remediated to state standards. And that is true all the way up until closing. Okay.
Jesse, how much does it cost roughly to have that done?
Yeah, good question. So there's at least one company called WeCycle, WEE Cycle, and they do both a full state compliant test, and then they do what they call a meth pre-check. And the meth pre-check is the exact same testing methods, just without all of the red tape paperwork that they have to provide to the state. And so if you just do the meth pre-check, it's been a few years since I had a client do one, but I think at the time it was like $900. Wouldn't surprise me if it was like $1,200 to $1,500 at this point. So it's not cheap, but man, meth remediation isn't cheap if you have a property that's, you know, infested with meth. We had one back in, 2010 or whenever, in Fort Collins, and the bank, it was a bank-owned property, and the bank had come in, they had painted everything, and they had put carpet in everything, right? And it looked like a brand new house. But the buyers get under contract and they start knocking on doors, right? Talking to neighbors. The neighbors were like, yo, these guys got arrested for manufacturing meth in the property. And they're like, what? So they do the meth test. Sure enough, it tests crazy hot for meth, even though everything had been painted, even though the carpet had all been replaced. This home tested super hot for meth. And so the bank bill for remediation, again, this is back, this is over a decade ago. The bank's bill for remediation on that property was like $75,000 just to tear it down to the studs, basically. But didn't even include the cost to rebuild. Okay. So you think $1,500 is expensive to do a little meth pre-check test? Like, wait until you have a property test hot for meth that you didn't know about, and then it's all bad. Okay. They're not all that expensive. I did have the one that my clients tested a few years ago. They had a meth pre-check done, and it tested just barely above the state allowable limits for meth. But it was above the state limit, right? And my clients had a son who already had some developmental disability and stuff. And they were like, whoa, I don't even care if it gets clean to state standards. We are not comfortable moving forward, right? But we asked the hygienist who tested the home, and we said, hey, like a little bit above the allowable use or allowable limits for meth contamination, which sounds really terrible. But anyway, we asked them like, this much above, like how much meth are we talking about? And she's like, probably, honestly, what happened was at some point they maybe had a party or something like that, and somebody went in the bathroom and used meth once, and it was registering, right? And that's where it tested the hottest, was in the bathroom. And so, that like probably that's what happened. The people who own this house, it was a beautiful home, really good condition. And I'm not like stereotyping here, but just, when you think of like a God-fearing Christian person, like you could tell, right? They had the Bible verses and crosses and whatever else. Very clean, very orderly home, looked beautiful. And lo and behold, like it tested hot in their bathroom. So they probably had a guest at some point who came over, went in their bathroom, used some meth. They didn't know about it. And I have no doubts that these people were not the people who did it. But bottom line is, my client wanted to get out. We asked the hygienist, like, hey, roughly how much do you think we're talking about cleanup costs? And they said, well, probably a couple $1,000s to have the vents industrial cleaned, and then a couple $1,000s to have someone come in with an industrial cleaning solution and wipe down the walls and hard surfaces and all these other things. So, maybe a $5,000 repair bill in that case. So they're not all catastrophic, but the other thing that I will say is Colorado's limits for allowable meth contamination are a little bit higher than a lot of other states. And so that's not super comforting to a lot of people. So just, I guess, know that, and you can educate your clients. Any other questions with meth? Usually we get all kinds of stories about this or questions. So anybody? Okay.
So
Real
you're
quick.
canceling your meth party?
Yeah, it's probably a good idea to cancel your meth party if that was the thing. So, real quick, we'll close a little bit early, but I'll just say section 11, tenant estoppel statements that also got deleted and moved to the income contract, but they keep it in here as a placeholder so that they don't have to redo all of the other numbers. So sometimes you'll see these things that are intentionally deleted. In some cases, they are permanently deleted, but they're in there as a placeholder because it would screw up a lot of other things in a lot of other contracts. So, okay, that's it. We made it through 3 sections today, too, if you don't count the one that we just went through, section 11. Congratulations. We'll get through it a little bit faster coming up. That was like the juicy stuff, some of the longer sections. I think we should be able to finish not next week, but probably the week after. However, actually, next week, I think there's something on the 6th. I don't remember what it is. Tell you what, I will double check and then I will send out a reminder next week. I'm looking at my contract. I have it. So I have a new home orientation next week for one of my deals. So probably we will not have contracts next week. So we'll pick it up on the 13th and then hopefully finish this one on the 20th. So if you guys have questions in the meantime, let me know, but I will send out a reminder on the Facebook group. So keep an eye on that. We could potentially do a shortened class, a 1-hour class next week. If you guys want to power through a little bit, and I guess since you guys are on the call, does anyone have a preference? Would you just prefer to skip it or would you prefer to do an hour next week?
Either way is good for me.
Would an hour help you get it done the following week, Jesse, or it doesn't matter?
I'm here either way, man.
I'd rather do an hour. I'd rather do an hour
Do an hour.
next week.
Okay. Well, we'll still probably do an hour then. It'll be that first hour, so 9 to 10. So we'll plan on that, but power through a little bit, see how far we can get. So, any other questions before we end it today?
Thanks.
Yeah, you bet.
Thank you.
Thank you, Jesse.
Thanks, Jesse.
All right.
Thanks.
We'll see you guys next
Thank
week.
you.
Okay, bye.